All right, we are live and it is on. I'm super excited about doing this. This is the first live on the YouTube channel. And so I wanted to actually start doing the lives because I get a lot of people who contact the office from out of state. And actually backing up a little bit, if you don't know me already, my name is Jamal Kersey. I'm a criminal defense attorney in San Diego, California. I've been practicing law for over a decade now. So it's been a long road, an enjoyable road, and I'm blessed to be in the position that I'm in. And I just really wanted to be more of a community resource to people. And so I decided to create this channel to be able to educate people, right? So, education is really important to me. The law I'm passionate about. So, I have my own practice. And I just found that I wanted to have a medium to be able to share my knowledge with the community. A lot of people don't have attorneys in their lives. They don't have any interaction or someone that they could call upon when they get in a jam, and so it's nice to be that resource to people. But fortunately, the business has been going well, so we get more and more clients every month, and that's great. But at the same time, because we're so busy, it can make it a challenge to be able to answer people's questions. And so, especially as it relates to this YouTube channel, we end up getting a lot of calls from across the country, people asking for legal advice, wanting representation. They watch my content, and what I have to say just really resonates with them, and so they want to reach out. They're interested in the service. And unfortunately, if you're out of state, so if you are not in the state of California, I'm only licensed in the state of California, so I can only help and represent people who are in the state of California. And so what ended up happening was I would have people calling, and even though I can't represent them, they would want legal advice or want me to ask their questions. Some people already had attorneys and wanted to get my opinion on what I thought about their case and seeing if I could help. And so again, if you're not in the state of California, then I'm not really able to assist. And so that's where the idea came. Well, if I start going live, then I can continue to educate people, continue to provide valuable information. And then with that information, I can also, have question and answer sessions, do some Q&A. And that would allow me to continue to provide value to all the people who follow the channel. So in this live, what I'm going to be talking about is criminal cases in general. So I'll be walking through some of the steps of a criminal case and basically the defense attorney's role, or what the defense attorney's role should be in a criminal case. And so what I'll also be talking about is what we do at criminal or at Kersey Law. So I know that if you've watched a number of my videos, you've seen me. I'm Jamal Kersey. I'm I own Kersey Law, but it's not just me. I have a whole team backing me. So I have Patty, who's my executive assistant. She's been working with me for quite a few years at this point. It's actually her birthday, so happy birthday to Patty. I've got my graduate law clerk Daniel, got my paralegal Eli, got my investigator Christina, operations Sven, my director of operations. I have a marketing team. I got my boy Nathan Johnson, who's been doing digital marketing for me for many years at this point. So, and then other people, other contractors who are able to help me do what it is that I'm able to do. So, and I'm very thankful for every member of my team who helps me get what helps me get the results that we do for clients. So I'm going to be going into how we handle cases, and then in the end, if we have anybody who has questions, then I'm more than happy to answer those for people. So I just want to start with when a person actually gets arrested. So when a person gets arrested and they're awaiting their first court date, so they may either be in custody or they may have bailed out of custody, and there's a gap in time between when they get arrested and that first court date. And so a lot of times people aren't sure, what are they supposed to do? Do I need an attorney at this point? What are my options? What are my rights? And so the first thing I want to talk about is what we call pre-charge investigation and negotiation, right? Because when you get arrested, that doesn't necessarily mean that you've been charged, right? So an arrest doesn't mean you've been charged with a crime. It just means that you were arrested. And so, presumption of innocence definitely applies, as it would even if you do get charged. So you are innocent unless and until you are proven guilty. And so that would be at a trial, right? So if you go to trial and you're found guilty, so then you're found guilty, or if you plead guilty. But unless one of those two things happens, you are presumed innocent. And so, but even though you're presumed innocent, there are certain consequences that can come from an arrest. So certain people may end up having licensing issues, whether that's a commercial driver's license, whether that's a license to practice law, whether that's a real estate license, whether that's a nursing license, whether that's a pharmacy license, all these different types of things where it could be in that person's best interest to not just wait and see what happens, because the reality is everybody who gets arrested doesn't necessarily get charged with a crime. So that's important to take note of, that everybody that gets arrested doesn't necessarily get charged with a crime. And what ends up happening is when there's alleged criminal activity that takes place, the police investigate. So they investigate the criminal activity, and then they turn their file over to the district attorney. So they turn their file over to the prosecutor's office, and then the prosecutor's office goes through that evidence to determine what, if any, charges are ultimately going to be filed. And so in that situation where there's potential criminal charges to be filed, there's stuff that can be done in order to possibly persuade the prosecution not to move forward with charges. And so, especially if a person has a solid defense, or if there's mitigation information, there's a lot of different possibilities. But that's where a solid defense attorney comes into the picture, to be able to get an understanding. Okay, what is going on? What's going on here? And getting the client's perspective in order to put them in a position where a pitch can be made to, again, to potentially persuade the prosecutor not to file charges. And so, for example, I definitely respect my clients' confidences, so I would never reveal anything that necessarily, that you would know who it happened to. But to be able to give you real world examples in terms of how this works. For example, recently we had a client who was arrested and they were in jail. And there was an investigation basically regarding a shooting, regarding guns and drugs. And so our client was former military and had security clearance. And so you can only imagine that if you are facing criminal charges for something relating to guns and shooting and drugs, then that's going to completely blow up your security clearance, right? So if that's your profession, that's what you live off of, that's how you put food on your table, then you really can't afford to just wait and see what happens. You can't afford to just hope that that the DA decides that they're not going to file charges against you. You're going to want to do everything that you possibly can to put yourself in the best possible position to avoid these charges being filed against you. So in that situation, we were able to get started on our investigation. So I had my investigator reach out to a number of people who were witnesses to the situation. and she was able to go out and get witness statements, and we took those witness statements, and we also were able to get positive information regarding our client. So that's another portion of the defense, is basically being able to tell our client's story. You see, the charge in and of itself and the case, they're very one-sided, right? So we don't even get to criminal charges unless the prosecutor actually believes that they can prove guilt beyond a reasonable doubt eventually, right? And so not only did the police that investigated the situation that led to the arrest believe that the client did what they arrested him for, but then the prosecutor does as well. And so that's one side of the story. But there's always multiple sides. And so our client's story oftentimes is very different from the DA's interpretation of what's going on. And so the only way that you get that information is by actually sitting down with the client and getting their side of the story and having them basically explain what ended up happening, what were the circumstances surrounding the events. And so in this particular situation, again, our client having security clearances and not being able to afford being charged with the crime, because just the charges alone, let alone a conviction, just the charges alone put his job at risk. And so he needed to act. And so we were able to spend time with him and get his side of the story. We were able to do our defense investigation. And not only that, but we were able to get positive information on his behalf. So there were a number of people who wrote glowing letters of support on his behalf, saying how good of a friend he is, how good of a coworker he is, how good of a parent he is, all these wonderful things. And we were able to take all that information, turn it over to the DA, and ultimately get a commitment from them that they were not going to file charges against him. And so that was, that was huge for him, because he was able to not only avoid felony charges, but able to hold on to his job, able to, again, continue to provide for his family. And that was really important. And a lot of times the analysis in that situation has to do with what is it that you have to lose if this goes south. If you get charged with the crime, what's at stake? Can you lose a special license that you have? Can you lose your job? Can you afford to end up having to explain to an employer that you got arrested for a situation and you're going to be charged with a felony or a misdemeanor? And for people who can't afford that, or people who don't want to take that risk, then that's where having a defense attorney come in sooner rather than later and just waiting and seeing what happens ends up coming into play. All right. And so in this situation, again, we're getting information together, we're doing research, we're interviewing potential witnesses, we're doing all this work before the case even gets filed. And that has the end goal of ideally being able to avoid charges being filed in the first place. All right. And so part of that, of what I was talking about, is the positive character evidence and contextual information, right? Again, when police write reports, a lot of times the defendant, or who will ultimately be labeled as the defendant, the person that's accused of the crime, is made out to look like a monster, right? So they're not putting a bunch of positive information about my clients in a police report. And so when the DA is looking at these cases and all they're seeing is a criminal history, if there is one, and then a version of facts that point to the client's guilt, right? Because if the version of the facts in the police report didn't point to the client's guilt, then he wouldn't have been arrested and he wouldn't be charged in the first place, right? So they're going to be very one-sided. And so it then becomes very important for us to counterbalance that with the positive information, right? So what are we looking for here? So I mentioned letters of support. So friends being able to say, hey, I've known Johnny for 20 years. He'd give you the shirt off his back. He's the most reliable person I know. He's a wonderful father to his children. These type of things. We have, family members, uncles, brothers, cousins, all these people who can say wonderful things about this person, again, to counterbalance the depiction of our client as a monster in police reports. Past and present employers. If we can have a manager or a former boss or a current boss who can say, hey, you know, Johnny's always coming to work on time. Johnny always goes the extra mile. Johnny will always do overtime if it's required of him. Johnny is the most reliable employee that I have. All these things end up factoring in, again, to counterbalance the depiction of our client as a monster. If they've received any awards, maybe he was employee of the year or employee of the month. He may have other awards, sports awards, anything to put into context who this person is outside of a 10, 20, 30 page police report that, again, makes him look like the worst person on earth, right? So volunteer work, a lot of our clients over the years, even clients charged with felonies, have done volunteer work. They volunteer at their churches. They volunteer, they're volunteer soccer coaches, they're volunteer football, basketball coaches. They give their time to the YMCA. These type of things are not going to be in a police report. Church, if you go to church and you're active in your church and your pastor can write you a letter. Hey, he's been active in our congregation for 10 years. He pays his tithes. That's gonna be a different way to view this person. Schooling. Does a person have any certificates or advanced degrees? Right. So these are again putting the character, painting the character, letting the prosecutor know who it is that they're actually dealing with. Do they have a long work history? He's been working in construction for 20 years, steady employment. So we're getting all this information in order to, if it is appropriate, because it's not always appropriate to reach out to the DA and ask them not to file charges. But to the extent it is, we would do that. But if not, we're getting all this information together because it's going to be useful for what would be the next step if the DA or the city attorney decided to file charges against our client. If they do, then there's eventually going to be a hearing called an arraignment. And the arraignment is the first hearing in a criminal case. All right. And so the purpose of the arraignment is for the accused to be made aware of what the charges are against him. All right. So he'll be formally read the charges against him, the exposure based on the charges. So what, in the worst case scenario, if you were found guilty of everything in this complaint, how much time are you looking at? You have a right to know that. You have a right to be made aware of your constitutional rights. So you're read your constitutional rights. And then ultimately, when you're in front of the judge, then the issue is going to be, entering your not guilty plea. The vast majority of people arraigned are going to enter a not guilty plea. If for nothing else, you haven't received any information yet, any evidence yet, right? So if the government charges a person with a crime, got my tea here. If the government charges a person with a crime, then they have the burden of proving that person guilty beyond a reasonable doubt. That person doesn't have the burden of proving anything. So if the government has the burden, then at the arraignment, there's been no proof provided yet. So there would be no reason to enter a guilty plea unless, the evidence is clear and there's already a negotiated deal. Then maybe in some limited situations, but the vast majority of time, there's going to be a not guilty plea entered. And then the other issue when we talk about arraignment is bail. All right. So whether the person is going to be able to get out of custody, and the things that the judge is looking at when we're talking about bail is, number one, whether the person is going to be a danger to the community, And number two, whether he's going to be a flight risk. Is he going to show up to court the next time he has a court date, or is he going to skip town and never come back? Those are the two things. And so there's a couple things that factor into that, right? So prior criminal history, if a person has a long string of violent felonies and drug offenses and all kinds of stuff, then and also the current charge, if there's violent allegations and the like, then the judge might perceive that person to be a danger to the community, right? So what they want to prevent is somebody getting out of custody and then killing somebody in the most extreme example, right? In terms of flight risk, again, they want to ensure that the person is going to show up to court at their next court date. So if they have a history of failures to appear, so they were ordered to appear in court, whether that was for a preliminary hearing or to submit proof or a readiness conference or an arraignment, and they failed to appear, then that's going to increase the likelihood in the judge's eyes that the person is going to be a flight risk. And so I was talking about when we're collecting this information, we're doing that in order to convince the judge, convince the prosecutor that our client is not a danger to the community, that he's not a flight risk. So those same very things that we collected earlier are going to be useful for that. We can show, hey, our client's been a member of this community for 10 years. He's been working at this job for 5 years. He's not going anywhere. He has kids here. His wife lives here. His parents live here. He's not going anywhere. In terms of the dangerous community, again, he's a member of this church. He's a volunteer here. He's been working here. He has no violent criminal history. These current charges are not violent. There is no danger to the community, and those are going to be the types of things that help you avoid your bond or your bail being set at a much higher amount. Because to the extent there are aggravating factors, that's what's going to lead to the prosecutor asking for a higher amount on the bail. The other thing that the judge will address are protective orders. If we handle a lot of domestic violence cases, and so in some domestic violence cases, the prosecutor will ask for a protective order, right, to protect the significant other, whether that's a girlfriend or a wife or the kids, because I'd say probably 8 to 9 times out of 10 the aggressor is the male, and so there may be an argument that needs to be made regarding a protective order. And that's another thing that that is definitely worth addressing, because we get a lot of situations where there's a girlfriend or a wife involved that doesn't really want this prosecution to move forward, that doesn't want there to be a protective order in place. And so in that situation, if they don't want a protective order in place, then we may have a conversation with them in terms of the judges and the DA's concerns. Are you in fear for your safety, right? If you're in fear for your safety, that's going to be a primary reason why there's going to need a protective order to be in place. And so if in the underlying facts, because this is also something that is really important to understand, the judge has to accept as true everything that the DA is saying with respect to release conditions, with respect to bail. And so sometimes, and that's why for me personally, I always let my clients know, hey, listen, if the DA is saying, if they're saying facts based on what they have in their police report, based on what was, reported, we're not going to be able to say for the most part that these things didn't happen, because the judge has to accept these as true for the purpose of setting bail and the conditions. And so, but what we can do to counterbalance these things is, again, present the positive information. Is also, again, if the alleged victim is on our client's side, being able to get their support, their indication, and obviously we're not trying to persuade them there are instances in which an alleged victim really is in fear for their safety, right? But if they're not, then and they don't want a protective order in place, because the thing you have to understand is at this point, there's a possibility of a judge making a decision that is going to impact um, at least two lives, but possibly more, right? So if the father of the household is removed from the house, then that can have a ripple effect on the children. Children ask him, why isn't daddy around? Like, where is he? And he's got to stay at his mom's house, or he's got to stay at his brother's house or his boy's house, because he's not allowed to be, near mommy. Right. So there's really important and serious implications involved when it comes to these release conditions. So we want to definitely be prepared for all that with all the information that we can, in order to make sure that if it's appropriate, that we ask for a different type of order. If there's a protective order in place, we might be asking for a no negative contact order, a peaceful contact order. Right. So, as long as there's no negative contact, or, there's peaceful contact, then it's okay. But if that protective order is in place, then, you are not to be within a certain amount of feet of your wife or your girlfriend. You're not to call, you're not to text, you're not to email, you're not to communicate in any way with that person. That's a big, that's a big invasion on a person's, freedom that they would otherwise have to be able to communicate with somebody. So that's the arraignment. And, shortly after the arraignment, the next date that's generally going to be in the case is a readiness conference. And a readiness conference is basically just to determine, is the case ready to proceed to the next step? In a misdemeanor case, that would be ready to proceed to trial. In a felony case, that would be if it's ready to proceed to what's called a preliminary hearing. And so in the interim between the arraignment and the readiness conference, generally the prosecutor is going to then provide the evidence. All right. So any police reports, any videos, any photographs, any lab reports. If we're talking about a DUI, we might have lab analysis. If it's if it's a violent crime and there were significant injuries, we might have medical records. Right. So they're going to turn over everything that they have that they believe ultimately, if presented in front of a jury, would point to our client's guilt. All right. And so when we get that information, we're going through the evidence. We're going through the evidence, and what you want to be looking for, or what we're looking for as defense attorneys, is seeing, okay, for every charge that is in a complaint, there are a set of jury instructions. And what jury instructions are the actual instructions. So it's the law that the jury is going to be considering when they're evaluating the evidence, in order to determine, did the prosecution prove the client's guilt beyond a reasonable doubt. So that's what they're looking at. They're looking at a set of instructions. And so what we do, we look at those instructions. And when we're looking at the instructions, we're going through the police reports to see, okay, are they able to prove this, or are they not? Or where are the holes? Where are the gray areas? Right. And so when we go through everything, we're taking our notes, we're looking at potential, red flags, things that stand out to us. And then we go through it with the client. Because the client has to provide their side of the story, right? The client was presumably there, unless we're talking about a misidentification case, or a case where a client says, well, no, I wasn't there, I wasn't involved. And that's relatively rare. So if they were involved, then they're going to be able to tell you what happened. And that's where I tell people, hey, listen, you're going to have your opportunity to tell me, this is a lie in this report. This never happened. This is an exaggeration. This isn't true. Okay, this is true, but here's my explanation. Okay, yeah, this is true, Okay, yeah, I admit that, no problem. But no, this didn't happen this way. This is a lie. This is an exaggeration. And we're going through that through every piece of evidence. Again, because I can't just make it up, right? I can't just make up a theory. I need to get my client's perspective. So it is really important that a defense attorney and their client be able to work together in tandem and the rest of their team in order to get on the same page and basically engage in a defense strategy session, which is what we do, in order to get on the same page as far as the defense goes. Right. And so when you're coming up with these defenses, there may be straight up legal defenses, right? So if we're talking about a situation where there was a traffic stop, there may have been an illegal traffic stop. There may have been a lack of probable cause for the traffic stop. The reality is this happens. I've been pulled over. I've been pulled over for no reason, right? No perceivable reason, right? And when that happens, if a person is pulled over for no reason, if a person is pulled over lacking in the situation, there's a lack of probable cause, then that can be legal grounds where any evidence that's collected after that can be the subject of a motion to suppress. And in that motion to suppress, that's where you would ask the judge to throw this evidence out because it was ultimately illegally obtained. There was no legal basis for there to be a stop in the first place. It's relatively rare, but hey, I mean, it's there. If the person was, for example, pulled over, officer says, I pulled you over for no tags on the car, and there actually was a temporary tag on the vehicle, that really should just lead to letting that person go. But if there's subsequent, excessive questioning and harassment and okay, I'm going to search your vehicle and the like, and they end up finding something, but there really was no original legal justification for the stop, then that might be the subject of a motion. So we're going through this information and looking for any potential legal issues that we can use in order to, again, protect our clients' rights, defend our clients' constitutional rights. And so illegal search issues, right? So any search without a warrant is presumptively illegal under the Fourth Amendment. Got a few people trickling in. It's good to see you. Thanks so much. So right now we're talking about going through evidence with our clients, right? So when we're doing this and we're looking, all right, were there any violations? If they do not have a warrant, there are some exceptions to the warrant to the warrant requirement, but generally speaking, police need a warrant to conduct a search. If police end up conducting a search with no warrant, then that too might be the subject of a challenge, right? And so um one piece of advice that I just have to say for you to walk away with is don't consent to searches. You have a right. You have a right to be free from unreasonable search and seizure for a reason. Don't just give up that right. I don't care if they sweet talk you about it. I don't care if they're aggressive about it. Don't consent to police searching your vehicle unless if you like voluntarily waiving your constitutional rights, then go ahead. But generally speaking, my advice is not to consent to a search. And obviously that should be handled respectfully. There's no need to be aggressive about the assertion of your rights, but just, saying I don't consent to a search of my vehicle. I'm not going to allow you. I don't consent to a search. But if they end up doing it anyway, because there are plenty of cops who don't really seem to care about the Constitution and will, conduct a search despite that, let them. Because if you get in the way of them doing their search, then that could end up being a charge against you. And so There are situations, Rowdy Rebel, I'm seeing, can't they check if they have probable cause? So there'd probably need to be a little more information if they have actual probable cause to believe that a crime has been committed. Then that gets into another issue because generally speaking, a warrant has to be based on probable cause. So generally speaking, if we just start from the beginning saying that police have to have a warrant in order to conduct a search. Now, again, there are exceptions to the warrant requirement, which is probably beyond the scope of this talk, but generally speaking, they do have to have a warrant. All right. And that warrant has to be based upon probable cause. And so, again, the thing to walk away with is demand to see the warrant. If they say they have a warrant, ask to see it. And if they don't, then say you don't consent to a search. But anyhow, that's, we're in this point, we're talking about the defenses that we're going through in terms of this review of the evidence with our client to determine how we're going to defend a case. And so generally speaking, when we're dealing with a case, there's going to be three possibilities, right? Either the client didn't do what they're being charged with, right? So they just didn't do it, whether it's a misidentification or the witness is lying or the alleged victim is lying or whatever. They just didn't do what they're being charged with. Another possibility is that they did it or they did something, just not to the extent that they're being charged, right? Or they actually did do everything that they're being charged with, but there may be some reasoning behind it. There may be some factual background or context that needs to be presented in order to really appreciate what they ended up doing. All right. And that could even be some sort of legal justification, right? If you get attacked and you act in self-defense, then in that situation, you're not going to argue that you didn't shoot the person or you didn't attack the person, but they attacked you first. And so you're arguing that you're justified in your actions. So again, when we're looking and going through the evidence with our client, because the approaches to those defenses are going to be different. But again, you don't know what that defense is going to be until you've actually spent the time with the client. And so going through with that information, at this point, we've already gotten a bunch of positive information from our clients. We have their work history. We have letters of support. We have all the positive information about them, positive information that makes them who they are. And we've analyzed their legal defenses. And so with that information, we're then going into what is the Readiness Conference. So we can determine, is the case going to proceed? Is it going to go to trial? Is it going to go to a preliminary hearing? Do we need more time? Do we need more time to investigate? Do we need more time to conduct legal research on an issue of intent? Do we need to look into our clients' immigration issues? Right. So over the years, we've handled a lot of cases for non-citizens. And so immigration consequences are a very real thing. Do we need more time to research that? Again, do we need more time to have our investigator reach out to, shoot video, to take photographs, to interview witnesses, whatever it is that we need? To answer your question, Rowdy Rebel, is it a good idea to keep a lawyer on retainer, even if a case was a DA reject? I'd say no, not really. Not really. If the case was rejected, then for the most part, that it's done, right? And so, short of any time that the lawyer spent on any research, investigation, conversations with you, most of that money should probably be returned to you. I just had that situation happen the other day. And so yeah, I don't personally believe in having people have me on retainer. Just keep my number, keep me locked in, right? Just keep following me on IG. If you need me, then contact me. But there's no need for me to hold on to your money. Again, ideally you never actually need me, but if you need me, give me a call and we'll go from there. So other people may view it differently, but I don't believe in having people keep me on retainer. And so when that next step happens at the Readiness Conference, that's when you're very welcome. That's when there's going to be a discussion whether, again, the case is going to settle or is it going to proceed to that next step. And so, generally speaking, at least in San Diego, there's a discussion in the judges' chambers where the prosecution and the defense are talking about their respective strengths and weaknesses of the case. And again, I'm going through this information because this is in large part information that you really can't get anywhere. There's not a lot of times there's not a book. There's not anyone who's going to tell you these things. And I just feel like it shouldn't be, it shouldn't be a secret. There's no secret to what I do. There's no secret to how to defend a criminal case. There's no secret to how to get a case dismissed. These are the things that you do in order to get there for your client, right? And so you're looking at these factual issues, legal issues, client's criminal history, and aggravating and mitigating circumstances. And the combination between all those things is what's going to lead to the district attorney making an offer to the client, right? And so in more serious cases, the prosecutor may not even make an offer, right? So I currently have an attempted murder case where the DA didn't make an initial offer. We had to come in with an offer, right? So it's a 2-defendant case. So me and my co-counsel had to go and pitch the offer to the DA. And so now we're in our negotiation stage at this point. So an offer is going to be made, and there may be counter offers. And again, ultimately, they're determining in a misdemeanor case, are we going to reach some sort of agreement? Might there be a dismissal, or is the case going to go to trial? And in a preliminary or in a felony case, it's being decided, is the case going to go to preliminary hearing? Is the case going to settle, or might there be a dismissal? And so there, really only the statistics vary, but depending on the jurisdiction, like only 2 to 5% of cases actually go to trial. So there's not a ton of cases that actually go to trial. And the instance in which a case is going to go to trial is because the defense or the prosecution just can't reach an agreement, right? And so realistically, in terms of that 3 to 5%, 2 to 5% figure, if there was much more, then the system would basically grind to a halt because there's not enough time, there's not enough courtrooms, jurors to process much more than that. And so there's an incentive on the prosecutor's side to attempt to settle cases, and there's an incentive on the accused side, because a lot of times the initial offer that they make you is going to be better than what it would be if your case goes to trial and you lose or you get found not guilty, right? So that's where there's an incentive to take a case or to take a deal versus go to trial. Now, there's a video that I've seen before, actually a few. There's people out there who say that you should never take a deal. And if you're never taking a deal, that inherently means that, you should take everything to trial. And realistically, that doesn't make sense. All right. That is, in my opinion, an uneducated, and I don't mean that disrespectfully. It's just that's not a lawyer's opinion. I don't know any criminal defense attorney who would ever say you should never take a deal. Even ones who really love trying cases. I love going to trial, but that would never be my advice to somebody. To some people, taking a deal is the best thing that they can do for themselves, for their families, right? And so I think a lot of times that advice comes from a very, again, uneducated. I just mean uneducated in the law. an uneducated anecdotal opinion that's based on their own, their experience, a bad situation that they had where they took a raw deal, or there was an attorney. A lot of times what happens is the attorney did not explain to them, didn't, what we were talking about before, walking through the evidence, going through any legal issues, any legal defenses. If that process doesn't happen properly, then the person may not understand why they should take a deal, why it's in their best interest to take a deal, right? Because the reality is there are people who actually did what it is that they're alleged to have done. Recently I had a case where my client had pulled a gun on the person, on the alleged victim, and it was on video and there was audio. There was no refuting that this actually took place. So to advise that person to go to trial would be foolish. At the end of the day, you play that video and it fulfills all the elements of that particular crime. So in that case, we were negotiating the best possible deal for our client. And we went through that same thing. We collected positive letters of support. We collected positive information regarding education history, regarding work history. To put into context, we sat down with our client to figure out, how did we get here? How did we get to this position? How did this happen? And there was contextual information provided, because again, that can help too. It can be really helpful for a prosecutor to understand why our client did what they're alleged to have done in that situation, right? Because there may be, it may not rise to the level of a legal justification, but it may be enough to put it into context for them to understand, especially if it was an isolated incident. If it was an isolated incident. So this was a one-off thing, an anomaly. This is never going to happen again. And especially if you can put things in place to show why it will never happen again. If the person had a lapse in judgment because they drank alcohol, if they had a lapse in judgment because they drink alcohol and now they're in AA classes, they've pledged to stop drinking. If drugs were involved and now he's in rehab, he's pledged to stop taking drugs. If there were some anger management issues and he's taking anger management classes, doing therapy, these are the types of things, because at the end of the day, the judge and the DA is going to be concerned with, all right, if this happened, how do we ensure that the public is going to be safe, or that the alleged victim or another couple or whomever, how do we ensure that this isn't going to happen again? And so the defense attorney working with the client is going to get all this information together in order to show the client's progress and demonstrate that this is not going to happen again. Another good question, Rowdy Rebel. How do you deal with cases that contain evidence not in favor of your client? And that's what we're discussing right now. Again, there are a ton of cases in which our client did what they're alleged to have done, and it does not make any sense to try and make an argument that they did not do what they are alleged to have done. All right. So if there's an argument to say that, hey, you can't prove it, because again, it's not whether the person did what they're alleged to have done, it's whether the prosecution can prove that. Right. And so if there's evidence that's not in our client's favor, then again, there might be a contextual argument for it that may not rise to the level of a legal justification, but it puts into context why they acted the way they acted. I had a client who years ago, who had been assaulted, and he had an unlawful weapon on his person. Now, him having made contact with police and they found the weapon on his person, if you just have that fact in isolation, you might think that, oh, he's a violent person, he's a dangerous person. But no, without the context that, he had gotten jumped very recently by multiple people and got really messed up. and so was on edge, and that was the reason why he had the weapon on him. So you can see how context changes things. When you have a factual background, when you have context, that can change, that can put into context why a person did, what they're alleged to have done. So there are different ways that you can deal with, unfavorable evidence. A lot of times there's unfavorable evidence in the form of witness testimony. And that's where, cross-examination comes into play. All right. So that's one of your constitutional rights that you are made aware of at arraignment. You have the right to confront and cross-examine. You have the right to confront and cross-examine all the witnesses against you. And you have that right. So if you're going to take the stand, then, or if a witness is going to take the stand against you and say, well, he did A, B, and C, then the defense attorney gets a chance to cross-examine that person. And when we're cross-examining people, we're looking at perception. Generally speaking, we're looking at perception, credibility, or bias, right? Perception. Were you in a position to be able to really see what you said you saw? Could you really hear what you said you heard? All right. Credibility. Do we have reasoning to doubt your credibility? Right. So you can call into question that person's credibility. Bias. If one of the witnesses is the alleged victim's best friend, and they might be, slanting their testimony in favor of that best friend, when my client's on trial, then I might be pointing out that, you'd be inclined to say whatever she wanted you to say, right? Because that's your best friend and you're not going to betray her, but you're more than happy to throw my client under the bus. Right. So those are the types of things, there are different ways to deal with these evidentiary issues, especially when they're less than favorable. You gotta get creative and figure out, like, how can I deal with these evidentiary issues? All right. And so as we were talking about, we're at the Readiness Conference and we're decided if it's if it's going to trial, then that's trial. And we'll talk a little bit more about trial. But as far as the preliminary hearing in a felony case, that Readiness Conference is to determine if it's going to go to a preliminary hearing. It's important to know what a preliminary hearing is. So a preliminary hearing is a probable cause hearing. And that's for the judge to determine whether, number one, whether there's been a crime committed, and number two, whether the accused is reasonably the person that committed that crime. All right. It's a low standard, but there is a standard in place, right? So the prosecution generally has to put on the minimal evidence in order to show that this person should be held to answer to these charges. That's what it's for. It's to make sure that people are not being held to answer to felony charges when there's no evidence. There's not even probable cause to have them, held to answer to trial on those charges. And so it's important. We also will educate our clients going into the preliminary hearing, because oftentimes you're not going guns and blazing into the preliminary hearing with your defenses. It's just not it's not the appropriate time, because at the end of the day, the judge only has to find probable cause in order to hold the client to answer to the charges. All right. Can you elaborate, Apple Tree? That's a unique name. What do you mean? And what if you don't answer? Yeah, elaborate on that question. So it's to determine whether there's sufficient evidence to hold the person to answer to those charges, right? And so a lot of times, from a strategic standpoint, it can be better, to negotiate a deal before the preliminary hearing versus after, depending on the situation, right? Because the stronger the DA perceives their case to be on the other side of the preliminary hearing, the worse the offer can get, right? So they may think their case, they may think, oh man, well, I don't really like to think in percentages, but they may think their case is relatively strong. But then they listen to the evidence at the preliminary hearing and they find their case is stronger, then that could result in a worse offer on the other side of the prelim. On the contrary, if it's exposed that there's holes in the case that they may not have been aware of, then that can lead to a better deal on the other side of the prelim. So the defense attorney really has to look at the evidence and confer with the client and make a strategic decision whether it makes sense to proceed with the preliminary hearing, or does it make sense to try and negotiate a deal before it gets to there. So what if you don't answer to making you admit that you did it? Well, I think really, I mean, generally, I mean, you have it, you, no, that's okay. We'll make it make sense. So you enter a not guilty plea in the beginning, right? And when you're presented with the evidence, then at some point you have a couple of decisions. You're either gonna admit to it and enter a guilty plea, or you're not, and then you're gonna move forward to, in a misdemeanor case, take your case to trial, or in a felony case, go to preliminary hearing. And then after the preliminary hearing, there'd be another, settlement conference, um and then if you still can't reach an agreement, or you either didn't get the case dismissed, or you didn't plead guilty, then the case goes to trial. And so those are the options. And so at trial, then the case gets put in front of a jury, and then the jury decides, guilty or not guilty. So that's I don't know that I if I answered the question or not, but that's basically the process as you go through. I mean, that in 30 seconds was, the process of a criminal case. So again, when it comes to that decision to take a deal, for me, I go through the evidence with my clients. And if they decide that they are going to plead guilty, it's because they understood that it just does not make sense for them to go to trial. It's not because they were scared into taking a deal. It's not because, they they felt like, I would be scared to go to trial, or I don't want to go to trial, or any of those type of things. It's just that we went through the evidence together. They understand the evidence against them. They understand what the witness testimony is going to be. They understand the videos that will be played. They understand the photographs that would be played. They understand what their defenses would be. They understand what our approach would be if we went to trial, and then ultimately made the decision that it wasn't necessarily in their best interest to go to trial. Because that's one of the things that I really don't like hearing, is that a person, ultimately decided to take a deal, and they felt like, I'm not guilty. I didn't do this. There's no evidence against me, but this is what I was basically forced to do. And so, um, and so, yeah, that's where, having that valuable time, and this can be hours, these defense strategy sessions, and there's not just one, there can be multiple, where putting that time in is what is going to help you get the best possible result in a case. And it's also what's most fair for the client, and what's going to leave that person feeling like it's what's going to leave that person feeling like, because the reality is this: people don't always finish their criminal case feeling happy about the situation, especially if they have to go to jail, or if they have to go to prison. There's nothing positive about having to go to jail or prison, but there can be, if you were looking at, let's say I had a client some years ago who had hired another attorney, and they were facing, they were signed up for a 9-year deal. Right. There was some priors, there was, some prior offenses, and then the current charges were pretty serious, and had already signed a 9-year deal. We got in there, and the problem was there was no information presented on the client's behalf. Right. So that this positive information that I'm talking about, in order to put into context the conduct, in order to paint the client in the light that he should be painted in, that didn't happen. And so we were able to negotiate a deal, and it was for 7 years. Now, at the end of the day, still had to go to prison, and that's a serious amount of time to do. But when you say, all right, would I rather do 7 years or would I rather do 9 years? Right? I'll take the 7. So in that situation, you can see the value in going through these steps, presenting the information on behalf of the client. Thank you, Rowdy Rebel. I'm glad you found it informative. Do I look at habeas corpus cases? No, I don't. There are people who primarily are attorneys, excuse me, who primarily assist with habeas corpus or other post conviction relief situations, and we generally don't do that. In terms of Kevin, what's up, man? I've never actually seen an episode of Better Call Saul. I've saw parts, but I've never seen a full episode, so I don't have an opinion on it. I did see Breaking Bad. I think that's one of the greatest shows of all time. And so yeah, everyone says, hey, you should watch Better Call Saul. It's even better than Breaking Bad. I find that hard to believe just because I love Breaking Bad so much, but I've never seen it. So yeah, I mean, the only other part that we're the in terms of the case and the steps of the case is trial. So again, if we reach a point where we can't come to an agreement, the case has to go to trial, then that's where you're putting the case in front of a jury, in front of 12 citizens, 12 of your peers who are making a determination as to whether the person is guilty or not guilty. And so some cases are appropriate to take to trial. Again, where you have a situation where the client is adamant that they're not guilty, they didn't do what they're alleged to have done, but the prosecution is adamant that they did do what they're alleged to have done, then the case might go to trial. Or I had a case years ago where there were a bunch of burglaries, and the evidence was pretty apparent that my client did what he was alleged to have done because there were a number of them. There are like 50 different burglaries alleged, and the evidence was pretty clear. But this was a situation where he was facing a ton of years because of priors and strikes and all kinds of stuff. So it was one of those things where might as well, let's go to trial. So, when we talk about like bad evidence and the like, at the end of the day, the government still has to prove the case beyond a reasonable doubt. And even though you may know that they can do so, if your client says, hey, I want to exercise my right to go to trial, let's go to trial. We will put together the best possible defense, even in a case that looks like there's, no chance of our client not being found guilty. It is their right to go to trial. It's their constitutional right, and I'm more than happy to, to ultimately uphold the Constitution and go to trial for my clients if that's what they want to do. So the only thing after that is really sentencing. And so for sentencing, generally speaking, we're presenting evidence, information to the court in order to request the least amount of time possible or the least restrictive conditions possible. And the prosecution might be asking for more time, but in that same situation, we're telling our client's story to the judge in order to get them the best sentence possible. Apple tree, is it better to do a fast? I can't even read what that says. Trial. Oh, trial. Or a long trial. There's not a better or worse. Some cases are just more elaborate than others or have more evidence than others. So in that case where I was talking about the 50 burglaries, that trial lasted a month. So we were in trial for a whole month, just listening to testimony after testimony from different homeowners saying that their house was broken into and that they, what items they lost and whether any of those items were recovered or not, and how the person or team broke into their homes and everything. So, just really the length of the trial is in large part driven by the volume of the evidence. Shouty. Let me guess. Are you from Atlanta? Are you from the South? Just out of curiosity. Can a deathbed confession be used in a court of law? That's a good question. So there is something that's called a dying declaration, right? And so really what we're talking about is whether it be admissible due to the hearsay rule. So generally speaking, hearsay is an out of court statement, right? So in order to present testimony in front of the jury, that the person who perceived what they're talking about has to actually come into court and be able to say, you know, Johnny stabbed me, right? Yeah, Kevin, he meant trial. So I'd I had answered that. Is it a fast trial? So long trial, short trial. So in terms of these deathbed confessions, so let's just say, the witness would say Johnny stabbed me, right? So at trial, in order for this witness or alleged victim in this situation, okay, Memphis, Tennessee, I really want to make it out to Tennessee someday. I really think that the music scene, the food, just everything, really want to make it out to Memphis someday. Check out some blues, get some barbecue, hang out at some spots. That would be a dream for me. But yeah, so Johnny would otherwise testify. I got, I got stabbed. Somebody gonna testify and say Johnny did it. That person would have to come into court and say, "Hey, Johnny stabbed me." We couldn't have somebody else testify and say that, "Oh, well, he said that Johnny stabbed him." But if that person is dying and then ultimately dies, and right before he dies, he says, Johnny was the one who stabbed me, and then dies, then that statement that would otherwise be hearsay could be admissible as a dying declaration. Why? Because there is a level of credibility that is lended to dying declarations. Most people, when they're on their deathbed or they're about to die, they wouldn't necessarily be inclined to lie. And so yeah, that's where the deathbed or dying declaration is the actual legal term. That's where that comes in. All right, so this is the this is the first live, and so I just wanted to present some information on top to bottom from the criminal case, what goes into it, what we do. And the reality is I want to, I'm new at this. This is brand new for me. And so I'll have it posted up and then people can look at it and maybe it'll be helpful to them. But I figured I'd probably answer a few questions, and I'm getting ready to wrap up pretty soon. It's hot in here. These lights are hot and I'm hot. This tea is hot. Shawty, if you come around, I'll show you. Oh, thank you very much. I appreciate it. That would be amazing. I may end up taking you up on that someday. So are there any other questions that anyone has? I don't see any more flowing in. So I think we're about to sign off. I want to thank you so much for being a part of my very first YouTube live. This has been a fun experience. I'll get to more. I know someone asked me a question about any advice that I'll have for people, in law school, anything that that I know now that I wish I would have known back then. And there's a ton of that, a ton of tips for, how to take the most advantage of your law school career and the like. And so I'll probably get to that at some point. Yeah, poor Johnny, Johnny getting stabbed. So yeah, Warren. So yeah, I'm glad that you found it interesting. I'm gonna get to that topic because that's one that I'm very passionate about. Like I said, personal development, entrepreneurship, career, lawyering. That's definitely something I'll talk about in the future. Can someone get arrested? And if someone's trying to get you arrested and they're doing it on purpose, um, yeah, I'll answer that for you real quick. That can happen. I had a client who had a particular special license that he needed to protect, and he was in a situation where his girlfriend, they were having some problems, and the girlfriend, and he basically threatened to leave her, and the girlfriend basically told him, if you leave me or even threaten to leave me, we're going to have problems. I will make things very difficult for you. And so thanks, Sam. Appreciate you checking in. Love you too, brother. Um, and so in this situation, she told him, I will make things very difficult for you if you leave me or threaten to leave me. She ended up causing her own injuries, which she ended up in the hospital and had bruises and had, significant injuries. And so, as you may or may not know, if you go to the hospital and you have injuries that look like you were attacked, or assaulted, then they have mandatory reporting requirements. So they have to report to the police. They have to get the police involved. So they did that. Police get involved. Police end up arresting my client for, assault, battery, domestic violence, all this stuff. And he ends up calling me, and we're in a situation where he's facing charges. Why? Because there are documented injuries that this woman sustained, and he was blamed for them. And so one thing that I've seen over the years is, and I mean no disrespect at all to women who have been legitimate victims of domestic violence. Domestic violence is real; it happens, and it's not my job to judge, but it does happen. But there are situations where women just use the police to scare people, right? So they threaten to call 911 or actually do call 911, and they have no interest whatsoever in the person actually being arrested. They just want to scare their boyfriend or their husband, not understanding that once you get the police involved and that ball gets to rolling, it can be hard, if not impossible, to make it stop. And so police got involved, client gets arrested, and again, he tells us, hey, listen, I didn't cause these injuries, but now I'm looking at these charges, and if I get charged, then I'm going to lose this, special license that he had, and he was going to lose his job, and wasn't going to be able to support his kid, and all this kind of stuff. It was basically going to go to hell. So we had our investigator, and actually, interestingly enough, I believe the alleged victim actually reached out to the detective and was like, no, this didn't happen. This is all wrong. I don't want this to go forward, because the police will ask an alleged victim of a domestic violence situation. They'll ask, do you desire prosecution? And if there's a case, will you cooperate? Right. So will you show up to court and testify if necessary and everything? And so she had said, hey, listen, I don't desire prosecution anymore. I don't want this to go forward. I'm not going to participate, if anything. And the detective was like, it's out of my hands now. There's nothing I can do about it. And I shot a video recently about this situation, and there's a couple practical reasons why that happens. Number one, you calling the detective after the fact and wanting to modify a statement just creates more work for that detective. So now they got to take notes about your statement and revise their report and get it over to the DA and all that. And they don't want to have to do that. Some don't want to have to do that. And then the other part is just the detectives and law enforcement officers, especially if you're assigned to the family protection unit or the domestic violence unit. They really feel, and rightfully so, right? They feel like they're doing justice by assault victims, and so a lot of times they won't let a case go because from their perspective, they don't want to have happen. For example, what happened with Gabby Petito, right? So in a situation where those cops ended up responding to that situation, and I think Gabby was all like shooken up and everything, and then the boyfriend The boyfriend ended up smooth talking the cops, I think, and then like they didn't arrest him, right? So they could have, but they didn't. And then, you know, a few weeks later or however long later, he ended up killing her. That's an extreme example, but that is the worst case scenario for, you know, for a law enforcement officer, for a DA, for a judge. Nobody wants to feel like, oh, well, if I had made a different situation, or excuse me, if I had made a different decision, then maybe this person would still be alive today. So that's what that mentality is what you're going up against when you're an alleged victim and you don't want a case to move forward anymore. And now you're trying to walk back what your original statement was. And so again, you know, so she hit a wall in trying to reach out to the detective and hoping that that would ultimately, you know, get dismissed, or the detective would close out the file. Fortunately, the guy had the presence of mind to reach out to an attorney. He called me. We discussed the situation, and so we were able to go about it the right way, because you know that's a common question. Can the, you know, can the alleged victim reach out to the detective? Can they reach out to the DA? Can they show up at arraignment and talk to the judge and say, "Oh no, well, I don't want this case to move forward anymore"? That's generally not going to be a good strategy in moving forward. If for nothing else, for the reasons that I just said. But what we were able to do is have our investigator take a statement from her in which she admitted, hey, I caused my own injuries. You know, my boyfriend didn't have anything to do with this. You know, I don't, as I said before, I don't want this case to move forward or anything. And so once we had that piece of evidence, if you will, that statement, basically a preview, because all a statement is ultimately a preview of what a person would say if they were on the stand and had to testify at trial. And so if you play that out, you know, in the original police reports, there was, you know, on or about this date, you know, the aggressor, we'll just say Dan, on or about this date, Dan hit victim. So Dan hit Valerie. You know, in law school, they usually replace the D with D names defendant, V with V names victim, Valerie, right? V victim. So Dan hit Valerie, right? And that's what would have been in the police reports. And that would have been supported by the hospital records that indicated whatever, you know, the injuries were. So the DA really in that situation would have had pretty much little to no choice but to file the charges. So in that situation, what we were able to do, like I said, is give them a report written by our investigator indicating that the alleged victim is indicating that she caused her own injuries. And with that, they were able to understand, all right, well, man, if we take this case to trial, then she would just take the stand and say that I caused my own injuries. And no prosecutor wants to look like an idiot in front of a jury by putting on that type of evidence. So that's what led to them making the decision to not file charges against our client. And that was monumental, because yes, it could have been a situation where they decided to file charges and then ultimately dismiss the case. But part of the problem is that they would have already had the charges. And it's a much cleaner look in terms of getting stuff removed from your record if you can avoid charges being filed in the first place versus charges being filed and getting dismissed after the fact. I know that was a mouthful, but hopefully that made sense. But yeah, it's better to avoid charges being filed in the first place versus charges being filed and being dismissed after the fact. And so for him, that was basically a lifesaver. That was a career saver for him, because he had an amazing job, a license that put food on his table, that both of which would have been lost if he had been charged with a crime. So that's the extreme importance of attacking these issues head on versus the just wait and see approach. Let's just wait and see what happens. Right. So this will be the last one. What if you say something by accident or just didn't say it right to a cop? That's why you shouldn't give statements to the police. There's a video, you know, I shot a video on, you know, don't give statements to a police. There's a short and there's a regular video on all the dangers that come with giving statements to the police. You know, you definitely, if you're under investigation, or if you believe you're under investigation, if you've been charged with a crime, if you've been arrested, you need to reach out to a criminal defense attorney immediately. And especially in that situation where people want you to come in, or where the cops want you to come in for questioning, and they're like, "Oh, well, I just want to get your side of the story." Dude, as between good cop and bad cop, I think good cop is the most dangerous, right? Because sometimes, the bad cop, if they're rough with you or whatever, I mean, that can intimidate some people. But the good cop is the one who is makes you seem like you guys go back 20 years. Give you some cigarettes, give you a cup of coffee, give you some donuts, you know. And then, hey, let's just talk this out. I can get you a better deal. I'll put in a good word with the DA. I'll put a good word in with the judge. And then then you start telling all kinds of stuff. You're giving them information they could have never gotten without your insight. Or you may feel like, hey, I'm innocent. I'm just going to tell them my side of the story and this will just be done away with. And again, inadvertently, unknowingly, you're filling in holes in their investigation that they would have never had this information about. And since I'm on this topic, I just really want to drive this point home, because sometimes people feel like, well, I don't want to be evasive. I'm law abiding. I'm going to cooperate with law enforcement. What do I have to lose? What's the worst that can happen to me? A lot of times, if law enforcement already has a theory that you did what they're alleging that you did, then there's really not going to be anything that you can say to change their mind. There's really not going to be anything that you can say to change their mind. But what you say, again, like they say, can and will be used against you in a court of law. So that's why it's best to, like they say, lawyer up, call a lawyer, get that lawyer's opinion on whether you should go in and make a statement or not. I'd say there's probably, I can probably count on one hand the number of times that I've advised a client in. So I'm going into my 14th, 15th year being an attorney. I've only advised a client maybe, less than 5 times to go in and actually make a statement. All the other times it's been no. Mm-mm. All right. So, should you take a I was about to cut it off, but there's too many good questions coming in, and I just know people are going to get a ton of value from this. And in the end, that's what it's all about for me. Because again, like I get these calls all day, every day. I get calls from people, from New York, from Texas, from Florida. I've gotten calls from Idaho, and I'm like, I can't help you. I'm licensed in California, but I want to at least, put information out there. But in terms of taking the stand and going to trial, there's two different thought processes. You have two different camps. Some people say, don't put your client on unless you have to. In other words, don't have your client testify unless you absolutely have to. So when would you have to? You would have to put your client on the stand in a self-defense case, right? So remember the whole Kyle Rittenhouse situation. So he had to take the stand. You can't assert self-defense if you don't take the stand. So some lawyers say, don't put on your client unless you have to. And then other lawyers, myself included, say, always put your client on unless you can't. So I prefer to put my client on the stand, and I'll tell you why. So the reason why the judge cannot make you take the stand. The judge cannot make you take the stand. You have a constitutional right to remain silent. So, when they say you have a right to remain silent, you have the right to remain silent, and that extends through trial. And even more importantly, there's a jury instruction, that the jury is not to hold it against the client if they decided if they decided not to take the stand, you are not to hold it against the client if they decide not to take the stand. Yeah, no, that's I mean, you hear that a lot. Don't take the stand unless you have to. I want my client to be able to take the stand. And so unless I can't, then I'm going to put them on. And the practical reasoning behind that is when you talk to prospective jurors. So the way you end up with that 12 is there's a whole room, that whole courtroom starts out full of potential jurors. And then you whittle it down to the 12 plus, one or two, three, four alternates, depending on the length of the case and the seriousness of it. And so when you're selecting a jury, you're asking them questions because you're trying to find the best jury. And the best jury is the one that's going to be fair and impartial. They're going to look at the evidence. They're going to issue their decision based on, the marriage of law and fact, not based on their own biases, not based on, their own sensitivities. So for example, if your client is on trial for a DUI and one of the jurors has a son who was, killed by a drunk driver, then you absolutely right. That person, despite their best efforts, probably could not be fair and impartial as it relates to a DUI case. So you wouldn't want that person on your jury, right? So you're going through and you're picking your jury. And one thing that I ask, because I really want to emphasize the point, I get into if there's a person, in the prospective juror pool who would say, hey, listen, I know that this person has a right to not testify, but if it were me, I would want to say my piece. Right. And there's always somebody who would say, well, yeah, if I was getting charged with a crime, especially, the more serious crimes, someone would say, hey, if I was on trial and I was being accused of this, I would want to take the stand and say my piece. I don't want any jurors holding that against my client if they elect to exercise their right to remain silent and they don't take the stand. But that's a natural thing that I think, even though people say, well, no, I'm not going to hold it against the client if he decides, to not take the stand. I don't want to have to deal with that. I'd much rather be able to put my client on and have them testify, unless I just feel like I can't, because certain evidentiary issues or certain positions that my client would have to take or wouldn't be able to take, or if it would be a situation where it would be more dangerous to my client for him to testify, then I won't. But I like to attack issues head on. And so for that reason, I'd much rather put my client on. Why would a judge make his decision by mail? I don't know. I don't know if you're talking about traffic tickets or something, but I don't handle traffic tickets, and there's no felony or misdemeanor cases getting any sort of decision by mail. So yeah, I'm not certain. Let's see, if you if you don't get all the jury to say you're not guilty, can they make you have another trial? So in terms of guilty, at least in the state of California, everyone has to vote guilty. So out of those 12 jurors, there has to be 12 who decide guilty. If they can't get 12, so if you have at least one person who would vote not guilty or more, obviously if it's all 12 voting not guilty, then there's an acquittal and it's done. But if there's at least one person who's voting not guilty, and then so you have a standstill, so you don't have a unanimous jury, then that's what would be called a hung jury. So you ultimately have a mistrial, and the DA would have the option of basically retrying the case if they want to. And so depending on the number of people who voted not guilty, if it's like one or two, then they might retry it. But if you have, 3, 4, 5 people voting not guilty, then, a lot of times they'll just not retry the case. They'll let it go. Can you pick the people for your jury? Yes, and you do. Yeah, and if it's people that so there's a list. There's a list of prospective jurors, and if there's a person that either party knows, then they'll generally be excluded. All right. These are good questions. In that case, you better call Saul. Wow, Kevin, you're gonna make me start watching Better Call Saul. Again, is it good? Who's seeing Better Call Saul? There's only 4 of you there. Yeah, I might have to check that out. Well, all right. I am now gonna close this thing out. Again, thanks so much for spending some time with me. I'm trying to figure out scheduling, see how often I'm going to do these things. It might be a weekly thing every Wednesday, touching on different topics. But yeah, this was the first one. All things considered, I gotta say it went well. I feel good about it. It can be tough being a beginner at something, and so I don't like. That's the thing. Like, I'm a hard worker, but I don't like being a novice at stuff. That's a challenge. And so I like to get through that initial learning curve as soon as possible, because I will push through the discomfort of being uncomfortable at something, right? But I don't like it. So I don't like being brand new at stuff. So I'm going to get done being brand new at this as soon as possible. All right. Well, cool. Well, save those Apple Tree, save those questions, and that just means that you got to jump on the next one. All right, guys. Thanks so much. I appreciate it. We'll talk soon. Peace out.